Thanks for having me. One of the things that I really enjoy about my career in intellectual property is that I get so much time speaking with inventors and developers and engineers and other technically minded people, but I don't do a lot of public speaking, and typically when I'm speaking in public, I'm in a courtroom and I'm facing the judge and everybody else is sitting behind me. So if you see me turn around and start talking to the wall, I'm just trying to find my comfort zone here. And a little bit about my background. I come from a background in hardware. I designed circuit equipment for Rockwell International way back when. I didn't come to software until much later in life, as when I became a lawyer. But I'm really developing an appreciation for object-oriented programming, and if they had it when I was in school, I probably would have changed course. But okay, let's get started. Now, I've always heard that I need to start a presentation with a joke, but I'm a lawyer. I can't start a presentation with a joke. I have to start it with a disclaimer. So I'm going to put it up here. Okay, now that you've had a chance to read that, no, okay. Any fans from the movie, the TV show Firefly here? Oh, yeah. Okay. Yeah, okay. Yeah, there's this one episode where Mel goes down and he gets married to Saffron but doesn't know it, right? And he comes back up and she's just like, "Hey, you're my husband." And he's like, "What?" No, that's kind of what that disclaimer was about. Is I can't, this is me, I'm giving you my opinions, my thoughts. We're having a nice conversation about things that are happening in the world, but I'm not your lawyer. We don't have an attorney-client relationship right now. I'm not, So that's what my partners made me do, to come out here and talk to you guys about this. So it's not really legal advice, it's just my thoughts on things that are happening in the world and how it might relate to what you guys are up to. Okay, so what are some things that happened in 2014 last year that I think would affect web development? One, Snapchat got into trouble with the FTC. The final settlement agreement was entered in December. The settlement was announced in May, but they published the settlement for everyone to comment on first to make sure they were doing the right thing. It was 2014, but really 2013 into 2014, retailers who had websites were getting sued for having certain features on their websites, even though you wouldn't think that retailers like Bed Bath & Beyond are technology targets. They are when they operate retail websites. And then something that came out late last year, Software Freedom Law Center released a new version of its compliance guide, which is quite intense, but there's a couple of nuggets in there that I think we need to talk about. Okay, now, I could be completely wrong, but in my imagination, this would be like the perfect world for you guys, is a website operator, and I'm going to use that term, I don't know if that's what you call them, it could be your client, it could be an internal client, it could be an external client, but they come to you and say, "Hey, I need a website, it needs to do this, these are my requirements," and then the developers provide that back, and that's all that happens. But we just saw that's not all that happens. The FTC can have something to say about it. NIST, the National Institute for Standards and Technology, has something to say about your websites. Patent trolls will sue you if you have the wrong or if you have the right features on your website. And then the open source community also has some impacts, but they're all facing the website operator, as far as I can tell. And you're over here on the other side of the screen as a developer. So I just want to talk today about some of these things that are facing the website operator, so you get some sensitivity to it. Why? Because they're going to come back to you, maybe indirectly. Maybe they're going to be in the software development agreement. Maybe they're going to be after something bad happens. I don't know. But eventually you're going to feel that. So that's why I wanted to talk about some of these things that are being experienced by the website operators. So, why do we care? Bad times. When something goes wrong, it will be bad times for you. Even if you don't think it's your fault, even if you're just doing what your client asks you to do, when something goes wrong, the bad times are shared. So you should know about it. And then the other thing, why care? Part two is you might have signed one of these agreements at some point where you signed a development agreement with somebody. And I think a lot of us would think that a software development agreement is something which specifies what the developer has to do to get paid and how the developer gets paid and what makes the client happy. But there's a second purpose for that. Software development agreements also allocate risk. That is one of the main functions of one of these agreements, is who bears the burden when bad times happen. And so oftentimes software development agreements include provisions for warranties and indemnities, and they will say who's going to bear the risk when there's a patent infringement, who bears the risk when there's copyright infringement, who pays damages when somebody gets sued, who takes the defense of the lawsuit. So these are things that you need to know, or I think you'd want to know going in. Okay, let's move on to something a little happier and less frightening, and these are the Fair Information Practice Principles. These have actually been kicking around for some time, it appears, going all the way back to the Privacy Act of 1974, I think. But for most of the time, most of the past years, they were principles that the federal government applied to itself. And now what we're seeing is that they are being pushed out onto everybody else. Not so much pushed out, but they're being held out there as benchmarks, as standards for companies' behavior in terms of how to handle personally identifiable information. And one of the main players here is that second one, the National Institute of Standards and Technology. So there's a subunit at NIST called the Information Technology Laboratory, and I think even within that, inside that, there's a computer security division. And they're out there writing these special publications. So when you see the numbers over here, SP 800-163, those are the special publications. And originally they were more concerned with controlling information for companies that contracted with the federal government. So that's the second set of bullets here. So defense contractors especially had to adhere to standards that NIST set up. And they actually wrote them into the contracts. And now they've taken a subset of the standards from this SP 853 and said even if you're handling non-classified but confidential information, you still have to adhere to all these checkpoints, or a subset of the checkpoints in 800-53. So, like I said, it started out if you were working with the federal government, you had to know what NIST was up to. But now, it's everybody else too. So now they're releasing recommendations and frameworks for companies to consider when implementing mobile applications, vetting the security of mobile applications, and when moving data onto cloud systems. So they've got these publications out there for businesses who aren't contracting with the federal government. They're just, ordinary businesses, and saying, hey, you should look into this. When you're rolling out new applications, when you're buying cloud services, when you are installing mobile applications on your employees' devices, these are the security considerations and privacy considerations that we think you ought to consider. So I think they're really becoming more important in terms of information governance within companies. Now, the information, like I said, Fair Information Practice Principles, if you Google it, it shows up in a lot of places. The FTC has a set. I think they started out in the Department of Homeland Security. The White House has been using it. I think the FAA adopted them. Well, they have 6 sites now where you can have experimental drones. The drone operators have to conform to the Fair Information Practice Principles. And so, it concerns principles for handling personally identifiable information. Of course, that includes name, address, social security number, ordinary things that we would consider personally identifiable. But there's other combinations that could be important. Geospatial location information, zip code plus date of birth can be very informative. I guess I heard that's like a 90% correlation. You can figure out exactly, a name, an identity from certain combinations of data. Some states like California, just an email could be considered personally identifiable information. So there's a lot of data that could fall within these these principles. But there's a lot of principles. We're not going to cover them all. And we're going to talk about a subset. And this is the subset we're talking about. Because this is the subset that requires coordination between the developer and the website operator. It's transparency, participation, data minimization, use limitation, security, accountability, and auditing. I promised Paul I wouldn't read the slides, but that one I had to. Okay. Take a breath. Transparency. These are why we get those notice screens on our website saying we're collecting this information and what we're using it for. Transparency requires you, though, to know exactly what information it is that you're collecting and where you're using it and with what third parties are you sharing it with to have it processed, right? And how are you storing it? Is it encrypted only while it's in storage, or do you encrypt it throughout the life cycle of the data, right? So these are the things that you have to notify people. We're collecting your mobile ID. We're putting cookies on your browser. We're, whatever. But the people who write the notices don't. Yes, go ahead.
I don't know if you're taking questions or not, but you mentioned cookies on your browser.
Mm-hmm.
That's not PII, is it? I mean, so.
No.
As far as I knew, in the United States, you don't have to notify people if you're putting cookies on their website. That was a UK law. Well, it wasn't, not US.
Yeah, there's a gray area when the cookies are being used for third parties to track activity for advertising. So if you're putting cookies on, and then also, for like analytics or a tracking beacon, then you've got third parties now who the people who reached your website wouldn't even know about necessarily are performing analytics. I happen to be one of the people who uses Ghostery, I think it's called, which, some websites you go to and you get like 12 beacons, half a dozen tracking or advertising type things, and so. It's not in the Fair Information Practice Principles, but there is a separate organization for advertising, and what they're trying to do is get voluntary compliance to alert people to the use of cookies. Now, a related issue is for mobile website and mobile apps. Is cookies don't work so well if you're using an app, you're not using a browser. If you're using a dedicated app, then they tend to use mobile ID. I forgot the exact name, but both Apple and Android platforms have two types of mobile IDs. One is a device specific, and the other is an advertising ID, and those are identified with actual people. So the mobile IDs are a much more sensitive issue than web cookies. Browser cookies. But, okay, so people writing notifications, okay? That's people like me. Lawyers are people too. But to serve our clients properly, we need to know what's being collected, what's being put down. Just because, and you'll see later on in the presentation, when you give a notice and the notice is incorrect, that's almost as bad or worse than not giving any notice at all. Oops. Okay. Individual participation means getting the consent. So after you provide the notice, if you go on and use it, if practicable, get consent from the people. That's when they click, yes, I agree with your terms, your terms of service. And when I say options must be effective, there was a case. Did I skip one? Okay. Options must be effective. there was a flash, I think it was somebody made an app for a flashlight, and they had an option to prevent information from being shared, but the option didn't work. All your information was shared by default. That was bad, as it turns out. Don't do that. Your options, to the extent you provide notice and you ask for consent and you don't receive the consent, you have to honor the lack of consent. Data minimization. Just only collect what you absolutely need to. The bottom point might actually be the most important one here. What I've been seeing over the last few years and through all these cases is the more information you accumulate. As you accumulate it and the bigger your subscriber base becomes, you're actually accumulating risk. Risk of the breach, and then when the breach happens, you're going to have to adhere to all the state laws for notification that the information was lost. So can you accomplish the purpose of the website by taking in less information that you originally thought? There's going to be an example comes up where an app collected the entire contact address book of the users. Could you have accomplished the purpose without taking everything? And so that's that's the point here, is only take what's absolutely directly and necessary to accomplish the specified purpose. Use limitation. Okay. So only use the data for what you told them you were going to use it for. It's a pretty simple idea here. The counter example to these bullet points here, which you guys can read, is an app. Golden Shores Technologies had the brightest flashlight free app, which was downloaded some millions of times by people who used Android. And as it turned out, what they didn't tell their people who downloaded it was that the app, when used, would transmit the precise location and device identifier to third parties, including advertising networks. Okay, so in a flashlight app, which was supposed to turn on the light on your handheld phone so you can see something in the dark, you wouldn't expect that the exact location of the phone and the device identifier, which is personally identifiable information, would get sent to third-party analytics for advertising uses. That's how you violate a use limitation. Security. Okay, and then so of course we all want to make sure that our applications are secure and they protect against loss. But the principles are phrased in the terms of appropriate security safeguards. And what I read that to mean is proportional. Okay, so what could be appropriate for some information wouldn't be appropriate for others. You would want to guard social security numbers with much more care than you would an email or somebody's name and address, which could be in a telephone directory. It's not even necessarily secret information. But there are some types of information which would get a much higher standard of care in terms of what's appropriate safeguards. And I'm not even talking about health records and credit cards. Those are under completely different schemes. Health records have HIPAA, which is a statute, a federal statute for governing those records. And the credit card company's payment card information has its own industry standard for what's appropriate for guarding those. These are just principles for, I'm going to say, PII other than health records and payment card information. Accountability. This is one I really thought was interesting because, of course, you want the companies that collect the information to be accountable for what they do with it and that they actually implement these principles and they comply with them. But provide training to all employees and contractors who use the PII and audit the actual use of the PII. To think of your clients coming in and giving you guys training as developers as to what you can do and not do with personally identifiable information, and then audit you to make sure you're doing it right. That's a pretty amazing obligation to put on the website operators. Okay, and we're going to go on to Snapchat, but I can stop here for a moment if you got any questions about what we just covered for the principles. Okay, Snapchat. So from what I understand, Snapchat is an app where you can take a photo, send it to a friend, and within a certain amount of seconds, on the example here, 7 seconds, it's supposed to be deleted forever. And from what I understand also, that this encourages somewhat riskier picture taking than you would normally do. I've never installed the app. I wouldn't know. But, you know, what happened to Snapchat? Well, as it turns out, those snaps didn't all disappear. The snaps were saved and accessed in ways that were inconsistent with the privacy policy and the other information that Snapchat presented to its consumers. And once you have consumers, nowadays you're going to also have the FTC. There is no federal government agency that is officially charged with policing the web for security and data breaches. But when consumers are involved, the FTC is going to get involved because they see their job as taking care of consumers regardless of the environment. What happens when the FTC gets involved? It's bad times again. The federal agency suing you and bringing you up is not a good time. So like I said, they're getting involved, the FTC is getting involved in breaches involving consumer personally identifiable information. They're also getting involved in when there's improper notice, improper consent to collect information, any false or misleading representations concerning the security of a website. One of the ones with Snapchat, I think I deleted the slide because I was running a little long, was they told everybody we use the highest possible standards for data security, and they didn't. But when we go through the actual complaint, which we're going to do in some detail here, is you're going to see that the FTC and the Fair Information Practice principles are actually pretty much lined up. They're interested in the same thing. So, like I said, there's no law that says the FTC must police the web and web applications. But the FTC is charged with protecting consumers and protecting against fraud, deception, and unfair business practices. So when it comes to consumers, a security breach is inherently harmful to consumer. Once their information gets lost, once it's out there and being used in improper ways, that's a harm to a consumer. And having insufficient notice and collection and use of data, misleading assurances of security, and basically bad documentation from your website, that's considered fraud, deceptive, and unfair business practices. So that's the basis of the action for the FTC to get involved and start investigating a website operator and getting into their businesses, and then extracting a consent decree which imposes basically corrective behavior on the website operator. How do we know exactly what the FTC wants? There's a nice long report that they issued in 2012. Expectations, once again, it's not law. But they're telling you what they expect. They're making recommendations for businesses and policymakers. And when you look at the table of contents, that's what these bullet points are from. It's the table of contents. It's the same things as the Fair Information Practice principles. They want transparency. They want choice, basically the individual participation. Retention limits, reasonable collection practices, security. It's all the same principles coming back again, but with a federal agency with enforcement powers, which NIST doesn't have enforcement powers, the FTC does. So let's look at a couple of things that got the FTC upset. One is in their frequently asked question page, Snapchat told their consumers, oh, the stamps disappear after the time's run out. And that just wasn't true. There were tools outside of the application where you could save those pictures. Now, that's interesting because it wasn't the app itself that was failing. It's that the app wasn't designed with enough security to prevent other people from using tools in the environment to take the data. It's how your applications interact with the normal environment that's important, not just how the app acts itself.
Can I ask a question
Yeah.
about that? So, in Snapchat's case, might an example of that have been simply that you can take a screenshot? Is that the kind of thing that they're talking about? Because like taking a screenshot of the app when it's up, even after the photo expires, now you've got the screenshot. Something as simple as that?
Yes and no. That was part of it, but it's actually, so there's our fair information practice principles. It went beyond that a little bit because they also, this next part of the complaint, if I can jump ahead, they told their users, we'll tell you if somebody takes that screenshot, like you said, that there's a way to take a screenshot, and they said, don't worry, we'll tell you about it, so at least you know. They were wrong about that too. Apparently on iOS, all you had to do was press twice really fast, and you were able to take a screenshot and defeat the security mechanism that would give the notice that the screen was captured. So once again, they're promising more than they can deliver in terms of security, and that is something that the FTC took some offense to. And the other thing, it's down here at the bottom. I think I have to use this once. I brought it. Whew, I have my laser pointer. Okay, widely publicized. So they knew Snapchat. The implication here is that Snapchat knew that their security measures were sufficient given the environment that they were operating in. And once again, these are our fair information practice principles: security and transparency. Tell them what's happening, and provide appropriate security for these photographs and other information. Yeah, Snapchat, they did a lot of great things. This is where they just basically lied to their consumers. They said they would not collect any location-specific information, and for their Android app, they in fact did collect Wi-Fi and cell-based information from the user's mobile apps, and they then provided it to an analytics tracking service provider. So they blew two of our, or at least two, maybe three of our fair information practice principles. One is they didn't provide notice that they were sharing information with the analytics tracking service provider. They didn't share, they weren't transparent that they were collecting it. They didn't allow people to opt out, so that's the individual participation and use limitation. How were their customers to know that by sending a snap from one person to another that their analytics were being tracked? So, and then the FTC is just really upset when you just lie in your documentation. This one is kind of interesting. I didn't read the actual terms of service that Snapchat had. My guess is they might have actually had a notice about this, but the way that the app was implemented by saying, hey, just enter your mobile phone number and we can find your friends, the FTC said, well, that implies that you're only using the mobile phone number. Okay, but in fact what they did was, as soon as you did that, they downloaded your entire contacts and address book, and no, not a good time again. That's transparency and individual participation, at least, probably accountability, because they're not following their own guidelines. So we're done with beating up on Snapchat. There were a few more good things in there, but like I said, we could have gone all night. So what do we learn from all this, though? Is everything should be in sync. Okay, the notice, consent, and the app should all be doing the same thing. Okay, and there's probably nothing wrong with collecting geolocation information. I mean, Google Maps does that, but I know that they do that. I want them to do that because I need to know where I am. Collecting address book information is probably okay. I know that there's apps like LinkedIn and Facebook that offer to do that, but they tell you. Providing third-party access, that's probably okay too. I guess that was one of the problems though, is they didn't lock down their API enough, and people created whole databases. If they use the third-party application to it, then the third-party app would capture everything. That's probably okay as long as you secure it, but I mean, it's a big if. If you've got to provide notice of the collection, use of the data, and that it's reasonably related to the use of the application. I mean, seriously, I think you know, just going back, I think half the complaint would be half as long if the documentation for the app just matched up with what the app did. How can we make life easier on our website operators, people who pay our bills? Don't collect anything more than they ask. If they ask you to implement a certain service and they say you're going to need to collect this for this, don't say, oh, but I can do it so much better if I get the whole address book, and don't tell them. No, only collect what they ask for, and communicate back how you're using the information to make sure they know exactly what's going on. Okay. And this one I think is one that's coming out more and more, is let them know if the site, if the information leaves your possession or the website's possession, if it goes to any third-party apps. And I don't know how these extensions work. I know there's many extensions for Joomla. I don't know if they send any data off-site to third parties for analysis and returning results, but that's something that you need to provide notice for, is when it goes to any third party. And then maybe, this is just my wishful thinking, maybe you read the website's privacy policy at the end and see if what you delivered matches what they're telling people. Okay, patent lawsuits. Big jump. Does anybody want to stop and ask questions about what we've covered so far? Yes?
What's the standard for providing notice? For example, our new Joomla Chicago website, we have a terms of service and a privacy statement. It's linked from the bottom of every page on the site. It says all use contingent upon our terms of service. And it pretty much says a bunch of stuff that we don't share people's personally identifiable information and stuff like that. But it seems like there's a lot of variety of, like, an app you get on your phone that just says, oh, I need access to this, and you click OK. And it seems like a lot of consumers don't bother to read the fine print. And does that factor into the FTC's consideration?
One moment.
For the folks online, please repeat the question so they can hear it
Okay.
before answering.
Okay, thanks.
I don't think I can repeat the whole question,
Okay.
but I think the gist of the question was just how much do you have to get into the consumer's face with your notice provision? How much do you have to prompt them to look at it? If you're a website, does CNN have to tell people that they're tracking everything? And how do they do it? If you're using a mobile app, how does that work? I think that it's actually developing more in Europe right now than it is in the U.S. Because the Europeans have higher standards for prohibiting the transfer of personal information outside their countries. Okay, and the web is very decentralized and doesn't care what country you're in. But the EU does care, the European Union does care, and they don't want personal information being exfiltrated without notice and consent. And so what you're seeing is a lot, especially in international websites, is a shaded portion of the screen comes up, and there's a notice, hey, we have a privacy policy, and if you don't click on this button, we're going to assume you're okay with it. And that's the kind of thing that I've been seeing adopted. I haven't seen anybody get challenged on that yet. As far as
you could just have the legalese say, this flashlight app is actually a user tracking and promotions app for benefit of our advertisers.
Yeah, that one's a little different. That one, I'm guessing that the flashlight app actually did have that buried in the notice somewhere, but the use of that data was so inconsistent with the stated nature of the application that just wasn't going to work. I'm going to go back and read the documentation on the case. I'm guessing that wasn't a failure to provide notice. That was just a use of data that is so inconsistent with the stated purpose of the application that it was just untenable in views of the FTC.
So what about a standard website where you have all these disclaimers in the footer? If nobody clicks on them and nobody reads them?
Okay, the question is what if you have a standard website with all these notices and a standard disclaimer and nobody clicks on them and nobody reads them? I'm going out on a limb here. Without having a very specific example in front of me, my general thoughts are that if you're not collecting information, that's probably okay. If you're just putting a cookie on the person's browser, putting a cookie down for normal purposes, retain the state of the website, so you know that they visited or which links they've already clicked on. That's one thing. Once you start collecting personally identifiable information, you better have an effective one of those things where somebody has to scroll to the bottom and click OK, I read the thing, even if they didn't read the thing. But something that's a little more defensible in that we made them scroll through this notice before we took the information in. Yes?
What if you as a developer discover personal information that's unsecured and that's available to the public, and the client doesn't want to fix that? Do you have some liability?
The question is let's say as a developer you're aware of some practices that don't comply with these the Fair Information Practice Principles, or in fact that there is PII, personally identifiable information, that is unsecured, but that the website operator doesn't want to do anything to fix it. And then I stood silently for a moment, not having a ready answer at hand. I haven't encountered that in real life yet. That seems really problematic in the sense that when these breach notifications go out, the people who send the breaches don't have to actually know that the data has been exfiltrated, has been sucked off the website. They just have to have reasonable cause to believe that it could have happened and that the data is no longer secure. So I think that's a real issue. I don't know how to tell you how to respond to that in terms of as a developer right now, but that's a tough one. Okay, I would say get a lawyer.
That was a tough one. I'll give you an easy one. Can you give us some examples of of PII information from a legal perspective? Like, I'm aware that probably Social Security is protected through the law, whereas maybe an email address is not. I don't know. So can you help me understand the difference between information about me and also legal PII information?
Okay. So the question is what's personally identifiable? Personally identifiable information in terms legally and what it means to us as persons. And it varies in context. Like I said, I think I saw something where California was moving to enact a law which said something as simple as an email address would be considered personally identifiable information. Of course, name, social security number, address, probably telephone number would be considered those things. Would be considered PII. I've seen in one application or one white paper for precision agriculture where geospatial boundaries of farmlands are considered PII now. So it depends on the context. I mean, I don't operate my own farm, but I have an address, and I would say, I think in my personal view, the MAC address and the SSID of my Wi-Fi router that Google went and collected everybody's information when they did the Google Street View. I would consider that to be PII, but that's just my personal opinion. And so different states have different views on what's PII. It's not an easy question to answer. But if you're not sure, it probably is to somebody, is the best way I can answer that. And it's, yeah. And if whatever gets lost, somebody's going to say that that's PII. That's what it's starting to come down to. We've talked about the FTC and we've talked about NIST. One of the things I didn't talk about are class action lawyers, and that's another. Once you have a data breach, you're probably going to get the FTC involved if there's consumers involved, but almost certainly you're going to get a class action lawsuit, and so they're going to look really hard at things and try to point to anything that they consider to be PII. But we're not talking about class actions today. They have their own set of problems. Anything else before I move on? Yes.
Yeah, I have a question. What constitutes a consumer? Like if you are registered to a site that you're like a member of, but you're not purchasing things, are you still a consumer? Like people who registered for free for this event, are they consumers?
We have your information.
You guys are asking hard questions. No, yeah.
Repeat the question.
Yeah, okay, so the question is what constitutes a consumer? Could it be somebody who doesn't pay anything, who's just part of the organization? And yes. Most people who join Facebook or Snapchat, I don't know about Snapchat, but Facebook is a free service for the users, but they would definitely be considered consumers in the view of the FTC when the breach occurs at Facebook. I'm sure they've had one already, and it just hasn't been public yet. Because, it's just an aside here. Basically, that's the other information. That's the other advice that your clients are getting is just assume that a breach is going to happen. Okay, so the best you can do is prepare for fixing what happens afterwards, and that's part of why we're doing all this. If they can go and say, hey, we've practiced all the fair information practice principles, we didn't collect any more data than we needed, did all those wonderful things, that helps them make a bad situation less bad. But yeah, the consumer, it's pretty much everybody. Anybody who uses the service would be considered a consumer. Okay. Patents. This is where I spend most of my time. I really enjoy patents. They help me sleep at night. No. It's tough reading sometimes. No, so what's happened, what was really interesting is usually when we think of patent lawsuits, we think of industry giants, Ford suing General Motors, or Samsung and Apple. They've just been tying it up with each other for years, and they are technology developers and technology makers and technology sellers, and that's where we expect to see patents, or pharmaceuticals. That's another great one. But retailers, Bed Bath & Beyond, and like I said, Oriental Trading Company, we represented in one suit. They're getting sued for patent infringement because they have web pages, and so what do we call these actors that bring what some would argue are nuisance lawsuits against entire industries at the same time? Well, yeah, we'll get there. So one name we use sometimes is non-practicing entities, NPEs. That's probably the kindest term. Then we have our patent assertion entities, which just purpose of buying patents and asserting them against companies that actually practice the technology. Now we're going down. Patent trolls are what the defendants call these entities when they're being sued by people who don't make or sell or innovate anything. And then there's other names that we're not going to use in today's presentation, but I've heard a lot worse. So what's one of the examples? This one, actually, I think we can talk about this one fairly safely now. I think all the patents have expired. They were getting pretty old when we were in this case. So this is public record. I can tell you we represented Oriental Trading. They got sued because they had a live chat button. Okay, now Oriental Trading does not make or sell live chat services, but they did include that functionality. It was provided by an external service provider. They included the button on their website. And they're actually, I put up a list here of some of the lawsuits. These aren't all of them. But they were included in this bottom case here with Crocs, Somerset Investments, and Saks. And they all happen to use the same service provider. I don't recall their name at the moment, but the same technology provider for the live chat. These other cases, these defendants, Nordstrom's, MakeMyTrip.com, Myers. So basically what happened was each one of these lawsuits represents a different live chat service provider. So the plaintiff went and grouped them by the people who provided that live chat technology so they could at least group together the same technical issues in the same case. And the defendants were just the people who ran the website. So out of curiosity, I went to Joomla.org and typed in live chat for extensions, and this is just the first page. I think there were a lot more than that. And the reason I bring this up is because if you Google live chat patent lawsuit, I'm pretty sure that there's the first result that comes up, at least when I did it, the first result that comes up is a Wikipedia page for Loadsys, these guys, and they tell you all about these lawsuits for these live chat things. So it's just, I'm not telling you that this is a really good idea to go, Google patent infringement case for every feature that your clients want on their websites, but sometimes the information is just out there. And if you sign that agreement which says you're warranting against all kinds of patent infringement and indemnifying your client, maybe we should be aware of the really big patent infringement cases involving common web application features. Another one, Edeca. These guys were great. They had something like 100 different companies in lawsuits, and then there was a rumor that Congress would amend the laws to make pleading requirements higher, more difficult for patent cases, and they went and filed claims against 87 new companies in one day in the Eastern District of Texas. And they were in Texas because Eastern District, Marshall, Texas, is known for fast-tracking patent lawsuits and jury awards with high dollar amounts. So if you're ever sued in Marshall, Texas, that's not a good time. That's something you want to avoid. But in this case, they alleged in just about every complaint that the activity that they found to be infringing, or they thought to be infringing, was making and/or using one or more websites that include shopping cart functionality. And yes, I went and I found the same thing. We got shopping carts all over the place. Like I said, I haven't looked at any of these. I don't know how they work. I don't know whether any of them have been brought into any of these cases. But it's just something that's out there to be aware of, that once there is a technology that's out there and used by dozens and dozens and dozens of companies, that makes it a target, because each one of those dozens of companies is willing to pay some tens of thousands of dollars to get out, rather than go through the cost of taking a patent infringement suit to trial and to judgment. Was it Newegg.com famously won't settle, but most of us aren't Newegg. So the tide's beginning to turn. As you might imagine, a lot of people are upset with the patent trolls. And so the first thing that happened was the America Invents Act implemented a couple of new post-grant review. So after the patent issued, new review processes in the Patent Office for challenging the validity of patents. One of them was the covered business method, post-grant review. Another one is inter partes review. Inter partes is just our way of saying that, that the people who brought the action to invalidate the patent get to talk to the patent office more than once. Ex parte means there's no communication. Inter partes means you have a back and forth. You have a dialogue with the patent examiner. And these were so successful that they've been coined death panels. So they're the patent death panels now. If you bring a petition for a computer-related or software patent to the patent office and they decide to initiate proceedings, I think we're running 70 to 80% invalidation rate. So they've been really effective. They're knocking out a lot of patents. One thing, I do have a qualification on that. Hang on, let me find it. I actually have this in my notes because this just came out yesterday. Judge James Smith, who's one of the judges, one of the administrative law judges on the Patent Trial and Appeal Board, was speaking at an event probably like this and said, one of the criticism of the proceedings and potential contraindication of success. Contraindication of success. That's great. So he's saying, people are talking about what a great success this is, and he's saying, no, a contraindication of success is that too many petitioners are winning, patent owners are having claims declared unpatentable too often, and the great number of filings is its own indicator of lack of this success, if not the way the board functions, but the overall development of the law with respect to patents. Okay, so the pendulum swung way to one side. It might be coming back. That's only one judge's opinion off the record, but the effectiveness of these panels has gotten the attention of the people who are rendering the decision. Other things that are going on. We've got action in Congress. Yes, our Congress. There's action. There's been some bipartisan effort to make it harder on trolls, to increase the pleading requirements, and to impose cost shifting onto the losing party if the case is found non-meritorious. Right now, there's a fairly high burden. You have to show I forgot, I can't come up with the exact legal phrase, but right now getting attorney's fees for a non-meritorious case is fairly difficult. They're trying to make that easier when the patentee doesn't practice the invention by themselves. Interestingly, one of the bigger hurdles to getting this legislation enacted is not our what's normal today, dysfunction in Congress, but it's different sides of the patent world. So pharmaceutical companies depend heavily on enforcing their patents. They don't necessarily want this, and big pharma gets big money out of their patents, and so they need to, or they feel that they need to be able to enforce their patents to protect their investment in developing new drugs. And so it is one of the issues that we have to deal with. How do you protect the innovators while at the same time not making it too easy for trolls to go out there and shake down, technology companies for the innovations that they're bringing to market. So that's something I'm a little less confident of, that something's going to happen in the near future, is that we're going to get a legislative fix. Not to worry, our Supreme Court has jumped in with both feet. And the case was Alice versus CLS Bank. And this was a case that had to deal with a computerized method for basically, I think it was escrow. It was, that's the basic idea. It was escrow. And so trades would be handled and no money would transfer till the end of the day. Everything was settled up, and then the accounts would be reconciled. And the basic idea that came out of that was, without getting into all the case law, is that the courts are now much more ready to find patents invalid when you can't point to an improvement in computer science, in programming technique, in the efficiency of the computer. if what you're claiming is your invention is taking a known method, a known business method, a known process, and just computerizing it and saying, now we do it on a computer, and we're sending this data over a network, and see isn't this much more efficient, those patents are getting knocked out. And partly it's because they're poorly drafted and they're not articulating what the real innovation is. But still, that's what's happening. It's still coalescing. Nobody really knows exactly what it means. The idea is that in the patent statute itself, it says you are entitled to a patent as long as you meet all these other requirements, new, useful, and it's directed to a machine, process, composition of matter, or manufacture. And so in the computer world, when we're claiming patents, we say, oh, it's a computer readable medium encoded with certain instructions, and that's considered an article of manufacture. Or it's a computer, general purpose computer programmed with instructions, and that's a machine. Or it's a process, which is actually the computer steps itself. And those literally meet the language of the statute, but the courts have been saying, no, we have these exceptions for abstract ideas and for laws of nature and natural phenomena. So you can't patent gravity. But they're trying to shoehorn all the computer patents into this abstract idea, but we don't know what they mean when they say abstract idea. It's one of these things where they say, well, we kind of know it when we see it. Nobody's come up with a good definition. And so I volunteered for a subcommittee for the Intellectual Property Owners Association, where we're going to try to come up with a legislative fix to say, hey, we're going to codify these judicial exemptions to Section 101, which determines patent eligibility, and try to write it out, because the courts are not helping. I mean, they're making it very difficult to understand by what they mean by abstract idea, in my view. And if any judges are watching, I apologize. Don't take this too seriously. No, it's very hard to follow the cases and come up with a single synthesis of what an abstract idea is. As we've seen lots of examples where they're considered abstract ideas. We've seen one example at the Court of Appeals for Federal Circuit where they said it was not an abstract idea, but we just don't have enough data points to make a good call on that right now. But, the middle point, it is having a deterrent effect. We're seeing just in sheer numbers of cases filed between the Patent Office review procedures and the law coming down from Alice, that patent lawsuit, just the sheer quantity is dropping. So those things are having some effect. Any questions on patents before I move on to the software? Let me see, what's Software Freedom Law Center. Okay, I'm going to move on. Okay, I'm not an expert. I'm going to say this right now. I'm not an expert on GPL compliance. But I can tell you, when I see something called the Software Freedom Law Center string together the words non-compliance, disputes, and eminently foreseeable in one sentence, that is something that gets my attention. It's probably going to get the attention of a lot of people. And this is what we were talking before the meeting about, this idea of the distribution of JavaScript. Okay, so what does this all mean? So Joomla is licensed under GPL version 2, and many of the extensions are. One of the things about GPL version 2 is if you're not complying with the license terminates automatically. You have an unlicensed website, that's copyright infringement. Okay, software development agreement says we warranty against no copyright infringement. Bad times if the website that you write is not compliant with the GPL license, because now your client is in violation of the license and committing copyright infringement. So we don't want to go there. Whatever it is that the Software Freedom Law Center is doing, let's not go there. And what are they basing it on? So there's a couple of main ways you can trigger these obligations under the GPL, and the obligation is to provide the source code and provide proper attribution. And the two main ways that I saw when I looked at it was distributing the program and modifying the program. Okay, and distributing, that means that's as long as you're using it internally, you can do whatever you want. Google famously has its own operating system. It's a variation on Linux. They don't distribute it outside the company. They don't have any obligation to publish the source code. Okay, and one other thing I have on this slide here is conflicting requirements are not an excuse in terms of complying with the GPL. So if you have different extensions with different licensing requirements, might want to look at that. Might want to make sure everybody is requiring the same thing so you don't have a problem. And this is a quote here. This is out of the GPL. It says if you want to incorporate parts of the program into other free programs, you got to ask permission or don't do it. Okay, so don't do that. And then this last slide here, this is the one where I think I get what they're saying. So JavaScript, JavaScript gets downloaded to the web browser every time the page gets loaded. And let's say that JavaScript that you're using, there's some feature or a micro app that gets run in the web browser that you got, and it's licensed under GPL. Each download of that JavaScript code could be considered a distribution, because you're even if the website's used only, you're never distributing the code for the website. You're only using it for one company, and they commissioned it specially for you, and they're saying it's not a distribution. We're not distributing the website. Is downloading the JavaScript or any other code in non-source form considered a distribution in the eyes of the Software Freedom Law Center? I think that, this was a shot over the bow. This is something that they say they're going to be looking at. This is one of those things where I would want somebody else to find out for me. I wouldn't want to be the person to find out the answer. Let somebody else figure it out and then tell me what happened. But that's just something I wanted to bring to your attention, because I don't know what it means. And questions. You see, I ended it on a question to you guys. You see. So I have questions for you. What does it mean when you download JavaScript? And do you guys download JavaScript that comes under a GPL license? But this is also the end of my prepared remarks. So I'm more than happy to take your questions at this time also.
I had one. It seems like a lot of the questions revolve around who takes on the risk, and standard website developer and software developer agreements with the website operator. I almost always, I warrant that the solution will work, but then, there's language that protects me from those sorts of obligations and costs and things like that. And in the past, I've seen that that's pretty common for software developers and folks to include it. And maybe this is a question for you. Is it more common for larger companies and larger development efforts to break out the risk and think about, who's responsible for what? Because for a lot of the Joomla market, I think there's small to medium-sized businesses who maybe aren't having their lawyer review the contract and things like that. Is there a best practice, or is there any problem with put the problems on the operator and do the best you can?
Yeah. So the question is how do risks get allocated, and it's partly in terms of the negotiation between the website operator and the web developer, it's part legal and it's part a business question. I think if it was up to me, if it was ruler of the world for a little while, I think it would be fair for the website operators who come up with the requirements list and say it has to do this, that, and the other thing, to take on the risk for patent infringement, because patents are generally directed to the functionality of the program, and it's not up to the developer to determine what features go in. He's told to put what features in, he or she, and that's what goes in. And so If it's something that's required by the web developer or the website operator, I would think that a normal allocation of risk would go to the operator. In my personal view, I think it goes the other way around for copyright. I think that since the ability to know whether or not you properly acquired code or whether or not you have rights to it, that's something that should be squarely within the control of the developer, and the developer should take that risk on, because there's no way that the website operator would necessarily know that it's being done properly. That's my personal view. In real life, it becomes more who has more negotiating power. Because what will happen when we see things like, I'm sorry, I'm pointing at a blank screen. When we see things like ordinary retailers being sued for patent infringement, that gets their attention. They don't want to go through that again. And to tell you the truth, it ends up getting pushed down to the developers anyways, because in those types of cases when the developer, it's the developer's work that is being implemented in a patent infringement suit, you either take care of your customers or you don't have customers anymore. And so I'm seeing more and more whichever party has the most negotiating power is pushing off as much risk as they can. And then the other party is either, well, I'm going to take the business or I'm not. And hopefully gets appropriate insurance if they have to take on the risk.
Kind of a follow-up to the last question. Do I have any, as a developer working for a company independently, do I have any different liability if I'm doing some pro bono work for an organization versus doing paid work for an organization?
The question is as a developer, do you have any difference in liability between doing paid work and pro bono work? And I don't think it matters. In terms of what we've been discussing today, patents, copyrights, no. Fair information, data uses, data security, I don't see any difference between paid and unpaid work. Okay. I'm not hearing anything on the earpiece.
Okay,
Jackie, are we okay?
in the chat. Okay, we're good.
Okay, thank you. Thanks for having me. It's been a lot of fun. I don't know if you could tell I was enjoying myself up here, but this was a lot of fun. And now.